Would this not be a great way to increase involvement of all citizens in the elections and to even the playing field so that independent candidates, Tea Party candidates, any candidate could reach voters and carry on a discussion about those social and political issues which need to be addressed during the heat of any good election campaign? This is Plaintiff Stephen W. Carlson's response to Defendant Mark Ritchie's motion to dismiss. Defendant's motion is purportedly based on the grounds that this court lacks subject matter jurisdiction over the instant action. In support of their motion, Defendant Secretary of State Mark Ritchie and OSS Legal Counsel Burt Black assert that the suit should be dismissed because, they say, it is based on 1. Non-existent constitutional rights, First and 14th Amendment U.S. Constitution, 2. A total disregard of the 11th Amendment to the United States Constitution, Minnesota case law interpreting the state statutes at issue, and 3. Speculative, quote, indeed false assumptions regarding central facts. For the constitutional rights asserted do indeed exist and need to be applied here to secure the rights they intend for plaintiff and for the voters of Minnesota. These constitutional issues are fundamental to the democratic nature of the nation and each of the states, which were required as a condition of admission to have a Republican form of government, which relies on electing representatives to govern in Washington. The violations of these constitutional rights runs counter to the Buckley Court's command that the court guard elections to, quote, assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people, unquote. Buckley states, in the past 2 decades, the court, this is the Supreme Court, has frequently spoken of the broad coverage of the First Amendment, especially in the area of political dialogue, quote, to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people. Moreover, defendants in the state of Minnesota advocate for the violation of the 15th and 19th Amendments U.S. Constitution by positively stipulating fixed percentage proportions of those who may vote based on race, color, and previous condition of servitude and on sex. The suit is not barred by the 11th Amendment, it is not moot, and it is in conformity with Minnesota election laws and the Constitution, which are in turn regulated by and must conform to the federal Constitution and law. And defendants Ritchie, as Minnesota's chief elections officer, and Black are the officials responsible for the constitutional implementation of those state laws, which as applied in this case are in violation of the U.S. and in fact Minnesota Constitution. And plaintiff will show and support the plausible facts alleged in the complaint, that they are not speculation nor false, and have not been shown to be so in defendant's motion to dismiss, that the court should consider the record of A-12-2286, an ongoing election petition at the Minnesota Supreme Court, which includes a proceeding to void the CD4 election, and also to consider the allegations of misconduct by election officials, that is, public officials with directly election-related duties, in the 2012 CD4 election, but also with respect to the 2014 congressional elections. Plaintiff has announced, stated, and affirmed in those state proceedings that he intends to be a candidate for office and does so again in my declaration I submit in support of this response. As such, the record now includes admissions by defendants in those proceedings. The record further shows defendants taking legal positions which contradict the positions they have asserted here, undermining and abandoning their contentions that their actions were required by Minnesota law. Defendant's instant response does not deny that Secretary Ritchie is a member of the DFL party, that the party requires quotas or proportional representation in the selection of all delegates who make the endorsement decision for the party, or that Representative Betty McCollum is endorsed through this kind of skewed and unlawful system. Regarding the email addresses, he refused to release during the 2012 election and continues to refuse to release, Ritchie, in his response to the 204B.44 petition at the Minnesota Supreme Court, begins with the same argument that he is absolutely prohibited by the, quote, public information list section of Minnesota Statutes 201 from releasing any but the enumerated data. However, beginning on page 33, Exhibit A, he admits, quote, the Secretary of State may provide copies of the public information list and other information from the statewide registration system for uses related to elections. Minnesota Statutes 209.091 Subdivision 4. And Secretary Ritchie stipulates to the fact that the use to which I would have put these email addresses, that is, contacting the registered voters in Congressional District 4, and we don't know how many of these email addresses have been provided, but there are 382,000 registered voters, and I was provided with their phone numbers. And he admits that IPAD, the administration department, has ruled that information not on the public list retains its presumptive status, that is, presumed to be public, under Minnesota Statutes 13.03 Subdivision 1. That this is the only reference defendants have made to the very material presumption of public information status under Minnesota Statutes 13.03. And so defendants from the very beginning have misled this court in the heat of the election on the applicable state laws and facts of this case. The email addresses are public information under state law, and were they not, the U.S. Constitution would require it. Or defendant Ritchie claims that Section 201 did not bar him from releasing the email addresses, but on the contrary confers discretion on him to do so or not. Thus, defendants admit that Ritchie simply decided in his discretion not to release the addresses. Defendants take the position that the law, quote, explicitly grants the Secretary of State the discretion to decide what information, both from the public information list and elsewhere in the statewide voter registration system, will be provided to the public, which is necessarily to say that he may decide not to provide that information. The constitutional violations complained of in the amended complaint are real and in need of redress under law. Defendants cannot be heard to say that the constitutional requirements on which this suit is based are, quote, non-existent, unquote, or fictional. The U.S. Supreme Court struck down as violative of the First Amendment, quote, provisions that place substantial and direct restrictions on the ability of candidates, citizens, and associations to engage in protected political expression, restrictions that the First Amendment cannot tolerate, unquote, from the U.S. Supreme Court. The provision referred to in Buckley were restrictions on expenditures for campaign, which in turn were used for political speech and association in election, but can be properly applied to each of the constitutional violations complained of here. Buckley held the First Amendment simply cannot tolerate restriction upon the freedom of a candidate to speak without legislative limit on behalf of his own candidacy. And they went on to say, we therefore hold that 608A's restriction on a candidate's personal expenditures is unconstitutional. Yet defendants give as one reason for not releasing the email addresses that they are scarce and extremely valuable, and that well-funded and supported campaigns like McCollum's may spend millions of dollars to gain that advantage. As such, defendants are advocating unconstitutionally for the disequalization of financial resources and free speech. In Citizens United, election laws of the kind the Minnesota legislature had in place were struck down, and in MCCL versus Swanson, Mr. Hartshorn's office defended the modified laws, which lifted some practices which violated the very constitutional violations plaintiff cites in this lawsuit, the First and 14th Amendments. There is additional change that is needed in Minnesota to meet the constitutional requirements properly regulated and enforced by the U.S. Constitution and Minnesota Constitution for Minnesota to clean up the selection process of its representatives in the U.S. House. One violations of the First Amendment applied to the state by the 14th Amendment through direct and substantial restrictions on political association and free political speech, through the denial of email addresses of registered CD4 voters collected by the but withheld from plaintiff. Plaintiff alleges that because I am a candidate who has offered, requested, and purchased the email addresses of the registered voters in CD4, I have standing to raise a case or controversy under Article 3 of the U.S. Constitution at both declaratory, injunctive relief, and damages. Plaintiff asked the court for a ruling that the withholding by Mr. Black violates the statute and the U.S. Constitution, and that the email addresses should be immediately released to me for use in my campaign and also in the 2014 campaign, so I can contact my voters. Plaintiff is still requesting the email addresses for political and election-related use as defendants concede. Now, Buckley protects any direct and substantial restriction on my right to advocate my candidacy by the United States and also by any state. Denial of email and social media linked by emails to registered voters in CD4 are, quote, provisions that place substantial and direct restrictions on the ability of candidates, citizens, and associations to engage in protected political expression, restrictions that the First Amendment cannot tolerate. This is because such restrictions fetter the interchange of ideas for the bringing about of political and social changes desired by the people, which is the highest purpose of the election. Buckley said, quote, the First Amendment simply cannot tolerate restriction upon the freedom of a candidate to speak without legislative limit on behalf of his own candidacy. This law that Ritchie sometimes says binds him, other times says gives him essentially unbounded discretion, but in any event he relies on to impose the direct and substantial restriction on the use of available state information on email addresses, offends the Constitution, because it is a legislative limit on my freedom to speak on behalf of my own candidacy, just like a law banning Mark Dayton from using his own money to buy media time. And here's the question. Could the state withhold information it collects on street addresses of voters within the district to protect the privacy during the election without offending the First Amendment? I would argue it could not, while defendants would have to contend the legislature would have such extraordinary powers. Money becomes medium. It is recognized as protected political speech when it is used to influence elections. Though defendants call it, quote, a nonsensical pretense, unquote, the email addresses are available public information, and they violated the First Amendment by restraining its use. Defendants say that they, obeying the dictates of state law, have merely declined to sell plaintiff for $30 the kind of electronic voter contact information that countless other campaigns in Minnesota and every other state spend thousands, if not millions of dollars to buy from private parties or to compile themselves. Thus they read in a requirement to go to private parties and to spend far, far more than $30 into free and fair elections and into the First Amendment. And they maintain and actually advocate inequality in election campaigns by building big money into it, protecting pecuniary interests in buying political advocacy during an election. They have no legal right to do this, and this constitutes corruption in elections. Defendants scoff that, quote, it is not defendants' legal responsibility to facilitate plaintiff's campaign, and plaintiff has no First Amendment right to access private voter information so that he can run for public office more cheaply. So do I have a First Amendment right to receive and use the 382,000 phone numbers of CD4 voters for political and election-related use? Doesn't that facilitate my campaign? Doesn't that allow me to access private voter information so I can run for office more cheaply? Isn't convenient and efficient access to voters freely and without legislative limit my right under Buckley? If there is a technical definition of prior restraint as content censorship, what I mean by prior restraint is that it is prior to the election, and it is a restraint, a direct and substantial restraint and limit on advocacy to further my campaign. Further, the Eighth Circuit in Minnesota Citizens Concern for Life versus Swanson, 2012, cited these cases as the reason for striking down the $100 fee to report campaign contributions, saying such election and First Amendment related laws are subject to, quote, the most exacting scrutiny, unquote, quoting Turner Broadcast Systems versus FCC from 1994, and requiring the government to use the least restrictive means, quoting Ashcroft versus ACLU 542 U.S. Supreme Court 656, to accomplish its compelling interests. Exacting scrutiny is more than a rubber stamp. See Buckley, describing exacting scrutiny as a strict test requiring more than a legitimate governmental interest. The Supreme Court has not hesitated to hold laws unconstitutional under this standard. This is quoting the Eighth Circuit. See Davis versus FEC from 2008, deciding certain federal disclosure requirements were unconstitutional under exacting scrutiny. And Buckley versus American Constitutional Law Foundation from 1999, Supreme Court, deciding certain Colorado laws regulating its initiative and referendum petition process failed exacting scrutiny. McIntyre versus Ohio Elections Commission, U.S. Supreme Court 1995, holding an Ohio law prohibiting the distribution of anonymous campaign contributions was unconstitutional under exacting scrutiny. And Buckley, determining a federal law limiting the amount of independent expenditures was unconstitutional. Reference Alvarez, 567 U.S., holding a federal criminal law prohibiting false claims of receiving military decorations or medals failed exacting scrutiny and violated the First Amendment. The Eighth Circuit went on, quote, as the Supreme Court recently reiterated, when reviewing a disclosure law, there must be a relevant correlation or substantial relation between the governmental interest and the information required to be disclosed, and the governmental interest must survive exacting scrutiny. Regardless of the association's purpose, governmental interest must reflect the seriousness of the actual burden on First Amendment rights. See Elrod versus Burns, 427 U.S., 1967. The interest advanced must be paramount, one of vital importance, and the burden is on the government to show the existence of such an interest. And I ask, has the Attorney General done this? No. Regulatory provisions, quote, no more than tenuously related to the substantial interest disclosure serves, fail exacting scrutiny. And accord McIntyre, 514 U.S., stating a law will withstand exacting scrutiny, quote, only if it is narrowly tailored to serve an overriding state interest, unquote. Minnesota's independent expenditure law almost certainly fails this test, they continued, and it overturned Judge Donovan Frank's denial of a preliminary injunction on state law for MCCL. Whatever legitimate objectives defendants and the legislature may have for either this ban on release of email addresses or the proportional representation system to achieve inclusion of women and minorities and other groups, neither comes close to meeting the vital interest in exacting scrutiny under the First Amendment as the Eighth Circuit sees it, being narrowly tailored or any other criteria in the compendium of First Amendment requirements collected by the Eighth Circuit to rebuke Judge Frank. And there is no way that defendants Mark Ritchie and Burt Black can meet this exacting scrutiny test when they are admitting in the Minnesota Supreme Court that they relied on Mark Ritchie's discretion to release or not release these email addresses. Now, my position is that every candidate in the United States, where under HAVA, the Help America Vote Act, they are establishing statewide voter registration systems and collecting the email addresses of the registered voters who offer them voluntarily. That there is no way that they can simply, by the discretion unbounded of Mark Ritchie or any Secretary of State, withhold those email addresses from candidates and, in fact, from registered voters who want to use them for political and election-related purposes. And I will leave you with this. Would this not be a great way to increase involvement of all citizens in the elections and to even the playing field so that independent candidates, Tea Party candidates, any candidate could reach voters and carry on a discussion about those social and political issues which need to be addressed during the heat of any good election campaign.